You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you please state your full name for the record?
The name is Todd Matthew Phillips. I believe that I'm free to file as many motions as I like.
I'll just end with this, Your Honor. Mr. Phillips has forfeited his right to file actions.
We're on record, Your Honor.
Good afternoon. We're on record in the matter of Phillips v. Phillips, D18. This is time and date for order to show cause why defendant Todd Phillips should not be deemed a vexatious litigant. May I have appearances starting with plaintiff, please?
Thank you, Your Honor. Dan Waite, bar number 4078 for the plaintiff who is here. I'll also note that her son, Mr. is here as well.
And he's an adult, correct?
I'm sorry?
He's an adult.
Yes.
Good afternoon, Your Honor. My name is T. Matthew Phillips, or Todd Phillips, as it appears in the pleadings.
And you're self-represented, correct?
That is correct, Your Honor.
Seat, sir.
Thank you.
Folks, my name is Heidi Almase. I'm the presiding judicial officer assigned to this case. On January 2nd, 2025, upon receipt of the case, I issued an order to show cause why Mr. Phillips should not be deemed a vexatious litigant. That was filed and served. It was amended on January 23, 2025. The correction included the city and state and zip code for Las Vegas and our actual courtroom designation here at the Regional Justice Center rather than just our department designation. For today's proceedings, this matter is pursuant to Jordan v. State XRL Department of Motor Vehicles. That case mandates that certain factors go forward in order to deem a party a vexatious litigant. Sir, if you are found a vexatious litigant following today's proceedings, my directive pursuant to that case is to issue limitations on filings. That make sense?
Thank you, Your Honor. Okay. If it please the court, I didn't know the range of prospective remedies.
I'm going to go over it, Mr. Phillips, if you just hang on for a second.
Thank you, Your Honor.
There are 4 factors in that case. The first one is that you be provided reasonable notice and an opportunity to oppose a restrictive order so as to protect your due process rights. This is a divorce proceeding between the 2 parties involving a former minor child who is now emancipated. The January 2nd, 2025 order to show cause as amended on January 2025 comports with the notice provision in that case. The second factor is setting forth the documents and basis for why an order to show cause would issue. We encapsulated that in our order to show cause, and I would note for the record that Mr. Waite, on behalf of the plaintiff, submitted his Exhibit 2, which is a compilation of cases involving you as a party. I presume that you had an opportunity to review that, Mr. Phillips?
Well, if it please the court, I did, but I also did wish to object to it. And if I could be briefly heard on the issue, it's styled as a response, but I didn't think that pursuant to any law that they had a right or a duty to respond. But because he submitted a proposed order, it seems to me that it's more akin to a motion. And if the court is inclined to consider it, I would ask to have 14 days to respond to it, which I think would be another week or so from today. But that was my
We'll go
feeling.
through the procedure, sir, and I'll make sure that you have an opportunity to respond, okay?
Thank you very much, Your
You're
Honor.
welcome. As we go through these proceedings, the third and fourth factors, sir, are that I make substantive findings as to the frivolous or harassing nature of litigants' actions, and any order that I issue has to be narrowly drawn to address the specific problem posed by your actions. Pursuant to today's proceedings, sir, I note, and you referenced it, the response filed by Ms. Phillips through her counsel, and then I would note you also filed what amounts to a responsive pleading in your January 28, 2025 affidavit.
Yes.
Okay. So the way that we will work today, sir, is I will have Ms. Phillips sworn in if she wants to provide any information through her counsel to the court related to today's proceedings. Sir, I'll also have you sworn in if there's anything that you want to offer. I may ask you some questions based on the order to show cause that has issued, and then we'll go from there.
Thank you, Your Honor.
Mr. Waite, do you wish to have your counsel, or not counsel, your client offer any testimony today?
I don't plan on it, Your Honor, but maybe in an abundance of caution, we might as well do it now.
Okay. And Mr. Phillips, you're standing.
I didn't know if you were going to ask me to swear in or.
Oh, not yet, sir. Custody.
Thank you.
Ma'am, I'm going to have Ms. Green, who's our Deputy County Clerk, just swear.
Can you please raise your right hand? You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you please state your full name for the record? Thank you.
And ma'am, you're the place for this action, correct?
Yes, ma'am.
Counsel, are there any questions that you wish to place on the record on behalf of your client?
No, Your Honor, maybe a point of clarification. It's my understanding in an order to show cause that Mr. Phillips bears the burden and would go forward, and we would respond, reserve the right to respond to whatever he presents.
Perfect. Ms. Phillips, you're standing as well.
Thank you.
Please raise your right hand for me. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you please state your full name for the record?
The name is Todd Matthew Phillips, Phillips.
Sir, you can have a seat. Mr. Green, the defendant in this case, is that correct?
Yes, that is correct, Your Honor.
And sir, did you receive a copy of the January 2nd, 2025 order to show cause?
Yes, I did, and I also received a copy of the Nunc Pro Tunc order as well.
Okay. Did you read the document in its entirety?
Yes, I did, Your Honor.
Did you understand it?
Only questions I had was regard to the prospective remedies, and if it pleased the court, I didn't know what the specific remedies that the court sought. I know it said that remedies may include this or that, but I didn't know exactly what the court had contemplated.
The Johnson case, sir, anticipates that if there are sufficient findings on the record, that the order, the vexatious litigant order, be narrowly drawn to address the specific problem posed by your actions.
Yes.
That might anticipate, for example, that any filings that you might wish to make before this court either be submitted to me for review, with a yes or no, it may be filed, or to the chief judge. That's an example.
Okay.
You would not be wholly restricted from the courts. That's the bottom line.
Yes.
Does that make sense?
Yes, it does. Thank you, Your Honor.
Okay. Sir, would you care to respond to page 2 of the order to show cause,
Yes.
specifically footnote 2? I believe you've listed approximately 102 pleadings related to this matter.
Yes, Your Honor, I do see that on page 2 of the order.
Sir, it's my understanding that a portion of these include custody modification actions after the child that you shared with Ms. Phillips emancipated.
Well, that would be not true. Respectfully, Your Honor, there were some lingering motions about some of the issues that it carried forward, but there were no attempts to see the minor child or otherwise get custody. I think the last one I filed was probably in 2023, so there's no new custodial-related actions. In fact, if I can explain here a little bit, when this came up with Judge Henderson, he had brought up the vexatious thing and decided not to declare me vexatious. But that having been said, the only issues would be economic. And I think all parties agree that custody has been disposed. And if there were any remaining financial issues, which I understand there are not, but they would be free to bring those. But frankly, I have no intention of filing any more actions. And if I could, I would choose to close the case. I responded to Mr. Waite, rather I've contacted Mr. Waite, but I believe they're disinclined at this juncture to close the case.
Sir, my review of the record indicates on average approximately 17 motions filed per year. Would you care to respond to that?
Well, may I stand?
You can
Thank
stand
you, Your
and
Honor.
come to the podium if you'd like.
I would say I'd like to begin by saying that the right to petition the government for a redress of grievances is, of course, a fundamental right. And that having been said, I believe that I'm free to file as many motions as I like. And the essence of vexatious litigator here in Nevada is based on Rule 11B. And specifically, Rule 11B prohibits litigants from filing motions that needlessly increase the cost of litigation under B1 or under B2 to make any legal argument not warranted by existing law. And under B3, parties are forbidden to make factual contentions that lack evidentiary support. Now, 102, I don't know if that's high or low on the average. 17 per year would be a little less than 1.5 per month. But in all of those 102 motions, Shannon Wilson, the prior counsel, never filed a Rule 11 motion, and neither did Mr. Waite. So it's my opinion that I have never violated Rule 11 in the instant proceedings. And to the extent the court considers other cases, I know there's been a lot of litigation in federal court, and I was unsuccessful in those cases, but no judge ever dismissed on a finding of frivolousness. No judge ever said this complaint lacks probable cause. No judge ever said this complaint lacks a factual or legal basis. The point is that I believe, to the extent this may be probative, I believe that my son was wrongfully taken from me. The reason I say that is because in this case, there's never been anything but he said, she said allegations. She claims domestic violence, that I beat her up with an open hand and a closed fist. But the truth is, there's no evidence of any kind whatsoever. There are no police reports, no 911 calls, no photographs of any bruises or anything that would be normally incident to a domestic violence claim. So it's always been my position that they never even reached the 51% preponderance. If it's he said, she said, I believe that's 50-50, and of course she has the burden of proof. I thought it was awfully unfair, if I can politely criticize Judge Ochoa, but he found domestic violence on clear and convincing evidence. Now, as Your Honor knows, clear and convincing evidence is that which can be corroborated or verified. Well, the plaintiff's self-serving testimonials is really just that. There's nothing to support it. And in fact, I would argue their domestic violence case in chief would actually run afoul of Rule 11b3, because they're making factual contentions that wholly lack any evidentiary support. There's literally no evidentiary support of any kind whatsoever. And I believe that I have a right to fight, if you will, to recover rights that are constitutional rights that I believe were wrongfully taken. I've had a chance to survey.
So, Mr. Phillips, I want to stick with, I'm moving through the order to show cause, and then
I understand.
I'm going to allow you to respond to the responsive pleading. So on page 2 and 3, we've listed out, as Johnson requires, all of the pleadings that we believe would be relevant to today's proceedings. There's approximately 102.
Yes.
Some of what you've just told me has to do with the merits or your disagreement with how things shook out in your divorce case, correct?
Well, it's really the reason that I've been fighting as strenuously as I can, because I was about to say that a lot of the vexatious litigating cases arise with plaintiffs who file complaints that really just shouldn't be a complaint, and they're really under a 12b5 standard. They just simply fail to state facts sufficient to constitute a cause of action. I believe that all the litigation, specifically all these motions that I filed, they're well-founded, and they were filed for no other purpose than trying to see my son, have an opportunity to talk to him. And with regard to these 102 filings, Shannon Wilson nor Mr. Waite ever filed a Rule 11 motion. So I know that if the court considers that a high number, my response would be that mere litigiousness standing alone would not be sufficient for a finding of vexatious litigant. In order to be vexatious, there has to actually be a Rule 11 violation. But again, because there's a fundamental right to petition the court for a redress of grievances, it's my opinion that I could put, you know, as much First Amendment as I want into the world, as long as I don't run afoul of Rule 11, which I believe I have not.
So you believe that of these pleadings that we've listed, sir, that all of them were meritorious or had meritorious claims?
Well, yes, I do believe they're meritorious. I understand.
Of those, sir, do you recall how many you prevailed on?
I don't think I prevailed on any of them, except for there was the two that I can recall is Your Honor partially granted a motion with respect to voiding out some of Judge Ochoa's orders in the wake of that disqualification.
So from 2018 until 2025, the motion that you prevailed on was the order that I issued related to the period of voidness, while the disqualification for Judge Ochoa was pending.
Yeah, and I think and the other one too, I think would be the disqualification in front of Chief Judge Weiss. And I believe there was another one too, now that I recall it. I had made a motion, I don't want to go too far afield, but Shannon Wilson would use the word threat all the time. Mr. Phillips made a threat. Mr. Phillips is threatening this one. Mr. Phillips, but she would never precede the word threat with an adjective of criminal threat.
And just so the record's clear, Ms. Wilson was Ms. Phillips' prior attorney.
That is Shannon Wilson. She works for Hutchison Steffen. And well, just in connection with that, I did ask Ochoa for an order to require Shannon Wilson, if she uses the word threat, to precede it with criminal threat or litigation threat, because litigation threat is obviously legal because there's First Amendment right of free speech coupled with the right to petition the government for redress of grievances in contradistinction to a criminal threat. And so I think that would be the totality of the motions on which I prevailed.
So, in the order to show cause, sir,
Yes.
we also talked about some of your appeals. You've indicated that you believe that the documents that you filed on page 2, which we listed in a footnote, your position is meritorious, but that the one you prevailed on was the one in front of me.
Yes.
You would agree that filing, or would you not agree, that filing custody modification after a shared child has reached the age of majority wouldn't necessarily be of any merit because the court has lost jurisdiction, or do you believe something else?
Well, no, I do believe that, and it's just to correct the record and be
Tell me
specific.
specifically what you believe.
I did not do any filings to get custody after he was 18 because obviously, and Henderson made it clear, and I acknowledged many times on the record that he has turned 18, and the custody. So I do not recall filing anything. I'm certain that I filed no actions after the minor child became emancipated on November 8th of 2024.
And sir, is it also true that you filed 6 separate appeals or writs? This is at the top of page 3 of the order to show cause.
I do believe that's correct, Your Honor. But,
Have you prevailed on any of those?
no, I have not, Your Honor.
Have you ever received a award of fees or costs for any appeal or any action that you filed here in the district court?
I don't believe so, no.
Okay, all right. And sir, in the order to show cause, we listed 11 separate federal complaints, writs, or appeals in the United States District Court, District of Nevada, related to this case. Is that an accurate statement to your knowledge?
It's probably accurate. I'm not sure it's the exact total, but there have been many litigations in the United States District Court under 42 U.S.C. 1983.
Have you prevailed on any of those claims?
No, I have not, Your Honor. If it please the court, if I could explain, in those matters I've met, I dare say that the motions, or rather those complaints, I believe are all meritorious, and certainly they have a legal and factual basis. But the problem I've noticed in doing the federal litigation against the judiciary is that the scope of the Stump versus Sparkman case, the Supreme Court decision from 1987, they've substantially expanded the scope of judicial immunity. I've also run into trouble under the 11th Amendment because, of course, judges are considered actors of the state of Nevada, and so the scope of 11th Amendment immunity is much broader than I thought. But I will say this, I don't regret filing those, even though I lost, because I was able to plumb the depths of judicial immunity as well as 11th Amendment immunity. And if I were to do it again, which don't plan at this time, I would have first, excuse me, filed for declaratory relief under 42 USC, because in one of the recent decisions, I think it was Judge Dorsey in federal court, who said that it may have been more appropriate to first seek declaratory relief. So while I didn't actually win any of those actions, I think they were, in my opinion, beneficial and a learning experience.
Sir, to your knowledge of those 11 cases that you filed in federal court, did any of them go to trial?
No, they did not.
Okay. And, sir, also on page 3 of the order to show cause, we've listed 5 different district court judges and 2 hearing masters which have been subject to private suit, including private attorneys, team chief for the district attorney's family support division, law clerk and judicial executive assistant to a district court judge. Do you wish to respond to any of those cases?
If Your Honor has a specific question, I can answer. My recollection is they're sued in their official capacities, as opposed, so it's not like I was, I remember some people were critical of me for suing the clerks, but it wasn't like I was suing them to levy on their bank account or something, but rather suing them in their capacities as state employees. As it turned out, they were granted the benefits and protections of 11th Amendment immunity. So,
Sir, did any of those cases go to trial?
as far as I know, they've never gone to trial, but if I may add, and politely,
Sure.
No judge in federal court ever said this case is frivolous and dismissed it on that basis. They have elaborate, well-reasoned, and some of them may have been more tenuous in my opinion, but the point is, I've seen many rulings from vexatious litigants, and you'll often see things like, it's unintelligible, they can't figure out which cause of action would go with which defendant. My pleadings, I believe, are very complete and straightforward, and I believe they do have merit. The one stumbling block has been judicial immunity and 11th Amendment immunity, which has significantly expanded, I believe, in the past couple of years.
So, sir, the order to show cause proceedings require that we list out all the basis for which we might deem you a vexatious litigant.
Mm-hmm.
So as I've gone through the order to show cause, my purpose is to ask you about those cases, your position on those cases and those pleadings. I have reason to believe, having read your affidavit and taking your testimony here today, that you believe that you've had or are entitled to full and fair access to the court process.
Yes.
And that the cases and or pleadings that you filed were filed for meritorious purposes, not for the purpose of harassing or vexing.
Absolutely.
Okay.
And
Either the plaintiff or anyone else.
Well, yes, absolutely. And, I want to say that very specifically. I fervently believe in every motion I filed, every complaint. If Your Honor would like to go over the causes of action or the various defenses asserted, I believe that it's intended only to see my son. I've had no contact of any kind since November of 2018, 0, and I have no intention to vex or annoy in any way. And I'll add this, on the various disqualification motions I've done, I purposely will do a request for disqualification as opposed to a motion, because if I were to file a motion to disqual, that would allow them an opportunity to respond. So I would file often requests. But as Your Honor can see, Mr. Waite is just happy to chime in, and I didn't think that he had the right or the ability to respond and request an order. But the point is, they're eager to do it. And I would say also, it's been my experience that in family court, the one party will try to burn out the fuse of the other side and they run out of money. It happens all the time. But I would submit to the court that is factually impossible in this case, because she spends no money. She's had the benefit of free lawyers, whether it's in Clark County Family Court, whether in Carson City in the Court of Appeals, whether in federal district court, even in the Ninth Circuit Court of Appeals. Indeed, when I went to the United States Supreme Court, she had a free attorney also.
Related to this case.
Related to this case. So it's my position that even if one were to ascribe to me a malicious motive of making her to want to spend money, it simply is not true. In fact, I've wanted to close this case, and I have email correspondence to Mr. Waite, who's indicated that he's just not ready at this juncture to close the case. And so...
Sir, is it true and correct that throughout the course of litigation in this case, that there have been awards of attorney fees and costs to the plaintiff?
I do believe there have been, yes.
Okay. All right. Let's talk about page 4 of the order to show cause. So you've indicated to me that you don't believe you should be deemed a vexatious litigant, correct?
That is correct, and if I could add something real briefly, the case law, without citing any specific points and authorities, taken in the aggregate, the viewpoint is that it's only in the most extreme cases, and generally with plaintiffs who file complaints, and I say that plaintiffs filing complaints that just don't make it. I think that the whole vexatious litigator doctrine was intended just for that, the person who files a complaint, meaning, a complaint for damages. Here, it's radically different because I'm a defendant, kind of trapped in family court, trying to fight to recover constitutional rights wrongfully taken. And there's case law in the Jordan case and DeLong versus Hennessy that says if someone is filing a motion or a lawsuit, what have you, that implicates a fundamental right, the court cannot make that part of a pre-filing restriction. Now, if I were filing what they call in California drive-by lawsuits for damages under, slip and fall, that kind of thing, when they repeatedly do those lawsuits, but they just don't rise to the level because the plaintiff's hoping to get a quick payout type of thing. Well, I think that the vexatious litigator doctrine is well suited to that. But when you're in family court and you can't settle the case, respectfully, I pride myself on trying to settle cases, but it's been absolutely impossible in this case to settle. They refuse, and I'm stuck. I have no contact with the minor child. I have no right to exercise...
The adult child.
The adult child now, but during the pendency when he was 12 and he left the home until he turned 18, there was no contact of any kind whatsoever. I have not had any opportunity, and I believe that violates my rights under Troxel because I'm a fit parent. And the Troxel fitness presumption says that a fit parent, like myself, and Mr. fit as well, but the point is a fit parent is presumed to be acting in the minor child's best interest. And it's always been my understanding, reading of Prince versus Massachusetts, the 1944 Supreme Court case, that if there are two fit parents, then the state respectfully has no business trying to enter the private family realm, is the word.
Mr. Phillips, I know that you're dissatisfied with the substantive posture of the domestic case, but I want to keep us on track with the
Thank you.
What we're here for today. If you would please respond to page 4, top lines 1 through 10. You'll note at our footnote 6, the court stated and found it is proper to consider the exhibits because Mr. Phillips' March 8, 2022 motion for relief from 2 orders dated September 9, 21, and March 14, 22 opposition to respondent's motion for relief from 2 orders, etc. Was never adjudicated due to Mr. Phillips' constant request for judicial disqualifications and appellate activities causing the district court to be deprived of jurisdiction. Specifically, in the top part, we cite to some statements that you made regarding soon-to-be-filed spin-off litigation likely to last 3 or 4 years. You will never get a straight answer. You are hardwired to be deceptive. On March 18, 2019, you wrote to an email to Attorney Wilson, expect a flurry of litigation, and you'll not be paid a thin dime for any of your work, hashtag guaranteed.
Yes.
Reading down line 10 and 11, on August 25th, 2021, Todd wrote an email to Attorney Wilson, this is Ms. Shannon Wilson, I have a new lawsuit for you. Will you accept service of process? Or maybe we should make this as expensive as possible. and this is how it was written out, you're already lost $179,000 in attorney's fees. How long are you willing to work for free?
Yes.
So, Mr. Phillips, you've testified today that you believe your litigation was meritorious.
Yes.
That you had good faith basis to file the motions.
Yes.
But correspondence included in these motions suggest a different tactic. Do you care to offer any testimony related to that?
Well, if I may ask, if I may politely voir dire the bench, what inference does Your Honor glean from the statements? May I ask and then respond there too?
So we issued the order to show cause. You have an opportunity to respond.
Well,
Your representations to me as we've gone through the order
Yes.
to show cause are, I have a right, there's a constitutional component to parenting. My motions were meritorious.
yes.
But in the context of that testimony, I'd like to know,
Okay.
because your attached
Yes.
documentation suggests something else.
Well, I would politely disagree.
I'd love to hear from you.
Yes.
What does this mean?
I think it's a little bit out of context because there's more to the story. I remember talking to Shannon Wilson and trying to resolve the case, trying to settle the case, telling her that I've had no contact of any kind whatsoever. No right to care, custody, and control under Troxel, no right to private familial speech under the Roberts versus U.S. J.C.'s case, and completely nothing of any kind whatsoever. And I told Shannon Wilson, I'm going to keep trying because I believe I have a fundamental right to see my son. Now, Shannon Wilson had lamented that she's not getting paid for any of this. I thought pro bono, frankly, when the case started, I thought it meant what I learned in law school back when I started in the 1980s, that pro bono means for good, and it doesn't mean that, well, essentially I think that Shannon Wilson may be more akin to a contingency fee lawyer. And I've had a chance to speak with other people to try to find out, other parents, have you been to family court, or rather the legal aid center, have you applied, and I cannot find anybody who has gotten free legal services in family court. And it occurred to me, and many other people informed me, that the reason Shannon Wilson took the case is because she figured that I would be easy to get a levy upon, and because she must have presumed that I had money as a lawyer, and if she won, she could get the attorney's fees paid. And I tried to explain to her, I'm broke, and I cannot afford to pay all the attorney's fees. Ochoa had issued around $300,000 and reduced it, I guess, by about $179,000 to make it more equitable. But the point is, I told Shannon Wilson, I will file bankruptcy if you get a court order and try to actually enforce some kind of levy or some kind of garnishment. I told her I don't have any wages, and because she's lamenting not getting paid, I said, basically, you see what I'm saying here, you're not going to get paid for any of this stuff, and I'm not threatening to file, ridiculous lawsuits. I'm telling her that I'm going to keep fighting.
Let's go to the top of page 5.
Okay.
Okay. Line 1. On December 22nd, 2021, Mr. Phillips wrote an email to Attorney Wilson. Quote, I'm going to do some more slash and burn litigation, the kind to which you've grown accustomed, the kind for which you won't be paid. But don't trip, I won't get paid neither. So before the parties spend inordinate amounts of time and money that will never be recovered, is there any remote possibility that can prevail upon your stubborn client? I need a phone call from you.
Yes.
So tell me in your own words what the slash and burn litigation refers to.
That is a term that Shannon Wilson would use in reference to what I'm doing, saying slash and burn litigation. So, it's
You
a
were just
bitter...
repeating it?
Pardon me?
You were just repeating it?
I was repeating her terminology, slash and burn litigation. So, it's probably a little bit acrimonious, maybe more than it should be, I don't know. But it certainly does not evince, in my opinion, any kind of vexatious intent. And I would say, for whatever probative value it holds, that intent is not a requisite element of a Rule 11 violation. Rule 11 essentially creates strict liability. If you make a legal argument not warranted by existing law, it doesn't matter what your intent is. My intent here is, you can see what I'm saying, is there any remote possibility you can prevail upon your stubborn client? I need a phone call. The order that Ochoa issued allowed me to have phone calls several times a week for several hours, but not once would Ms. ever bring the minor child to the phone. And I made an OSC to make her bring the minor child to the phone, but
So I want to make sure I understand you, Mr.
Okay.
Phillips. Your position is the comments that we've included in the order show cause are either taken out of context or they occur in the context of acrimonious divorce and custody proceedings.
well, I mean, that may be a little bit, but I'm telling her that that basically, as long as I have no custody of any kind, no care, custody, control, or private familial speech, I'm going to keep fighting. And if she's going to lament not getting paid, and it's taken from my practice as an attorney in California, my son is the most important thing to me. And I believe I have a right to fight, not only for me, because I believe I have a constitutional right to parent, but I believe the minor child has a corollary right to be parented. And knowing he has a right to be parented, I want to fight for him as much as I'm fighting for me, because there's plenty of language in the codes, in NRS, that speaks to the court wanting to maintain frequent and continuous contact with the minor child, even after there's been a divorce or a custody decree. But I never, ever once got to even have one word on the telephone. And when I filed the OSCs, Your Honor is asking me questions, and I'm happy to respond in a complete and straightforward manner. But when it came time to scrutinize Ms. They never really asked why it is that she couldn't bring the phone. And another thing I found really upsetting, if I can be candid here,
So
is...
Mr. Phillips, again, I appreciate that the substantive nature of how things shook out
Thank you.
in the relationship and with your now adult son
Mhm.
did not end out in a way that was satisfactory to you. I want to make sure I understand that the comments, the nature of the comments that you've made, you represented, one, they've been taken out of context,
Mhm.
and two, you testified that they occurred in the context of acrimonious litigation, correct?
Well, I mean,
Is there anything else you want to tell me about the nature of those comments?
they are just meant to inform the other side that I will keep trying because I believe I have a right. And frankly, I think it's really unfair for the opposing party and their attorney, Ms. Wilson, just to say that I don't get any contact. The point is, I believe I have a right because it's a constitutional right, not just to petition the government, but because I have a fundamental right to be a parent. And I think Judge Henderson noted that the whole case is in many ways a crying shame that I never ever got to speak with my son or have any contact despite filing what I earnestly believe were meritorious motions and meritorious complaints. And I mean that sincerely, Your Honor.
Can you tell me, sir, how the ancillary litigation helped you have contact with your son or deal with the substantive issues in the divorce case? And by that, I mean
Right.
Various motions for disqualifications, various private lawsuits, various federal lawsuits. How did those assist you or bring you the answers that you were looking for in your domestic case?
Well, obviously, the motions to disqualify were not, to see the son necessarily. But I perceive bias, and the standard for bias under the Rippo versus Baker United States Supreme Court case is whether a third party looking in would have reasonable grounds to suspect the judge may be impartial. And under that test, I would file disqualification motions where I felt the judge was frankly not giving me a fair shake. Now, on the federal actions that you mentioned, some of them were to recover custody. And I can recall some of them were specifically to recover custody, and other ones were to create precedent, specifically create precedent that there have to be constitutional guardrails on taking away children. When I first lost my son, I had no hearing and no opportunity, no notice or opportunity to be heard. My son was summarily taken from me, and I believe that was a 14th Amendment violation. The case of Matthews versus Eldridge and Fuentes versus Shevin Supreme Court cases specifically say when a fundamental right is at stake, that I'm entitled to notice and opportunity to be heard. Well, my son was taken from me, and that was it. And there was no looking back for the other side. And again, it's regrettable, but I never once got to talk to my son, and I was all times in earnest about seeing him. And some of the cases, again, even in federal court, if they didn't actually bear on that, I was trying to create precedent that I believe would pave the way for other pro se litigants who may not have the benefit of the education that I've been lucky enough to have.
Mr. Phillips, is there anything else that you would like to tell me or any other argument you would like to make before the court related to the order to show cause?
Well, I would, one thing I would like to say, respectfully, Your Honor, I'd like to add was my thoughts on the particular remedies here. And
I also would like to hear, I don't want to cut you off before you get an opportunity to respond to the response filed by, I know your name's not Ms. Phillips, but
Legally it is.
the plaintiff. So would you like to respond to the response that was filed and then give me anything else you'd like to tell me?
Well, if I, considering if she enlarges the scope, I would like to have an opportunity to briefly respond. I don't mean to be too verbose, but I will keep it brief. Thank you.
The scope, sir, is whether or not you should be deemed a vexatious litigant.
Yes.
If you were deemed a vexatious litigant, again, I'd have to issue an order as narrowly as possible restricting, based on the finding. Your name would be submitted to the Administrative Office of Courts, and you would be placed in the vexatious litigant database for the state of Nevada.
I'm aware of that. And if I could ask one question?
Sure.
Would I have a right to appeal such an order if indeed Your Honor were inclined to issue it?
I believe that your appeal right, sir, would be by writ.
Thank you very much, Your Honor.
Would you like to tell me anything else about the order to show cause?
Not at this time, Your Honor.
Okay. I'm not going to come back to you, so is there...
Let me check real quick. I would want to add one thing. I noticed it wasn't in not the moving papers, but in the OSC, that litigiousness is a fundamental right. And litigiousness, standing alone, is not a ground for vexatiousness. And I believe litigiousness, even if you have a 0% batting average, like I guess I would do, or slightly above 0%, but the point is, I don't think that that alone would do it. There has never been a finding of a Rule 11 violation in this court, and they've never brought a Rule 11 motion. And I can say the same thing for those the courts and the actions in the federal district court. And before I rest, I would say, I want Your Honor to know that I am sincere.
I appreciate that, Mr. Phillips.
Thank you, Your Honor.
Thank you. I take it, Mr. Phillips, you'd like your argument related to Ms. Phillips' response to Stan that you made at the beginning of our hearing, that you didn't feel like it was appropriate or needed?
I'm not sure I understand the question, Your Honor.
So Ms. Phillips, through her counsel, filed a response. I
Yes.
referenced the Exhibit 2, which is the compilation of cases,
Yes.
and you indicated that you did not believe that the responsive pleading was appropriate or necessary.
Well, I think it's EDCR, it's in the 5,000s, but it talks about procedures when somebody files a motion. And as it turns out, this was a sua sponte order, I guess would be the way to characterize it. And typically it'll say notice of motion, you have 14 days to respond. Well, wanting to be respectful to the bench, it simply says I'm here to appear, so I didn't want to file a responsive pleading. And also knowing that the court may not want to entertain any more motions, I thought I would just, but there's no basis, I think, and procedurally, there's no statute that says that they get to respond to an OSC. And if you look at the scope of what they introduced, it's significantly larger than what Your Honor had contemplated. And the fact that they submitted a proposed order says to me that it's really a motion. Even though he styled it as a response, if you look at the substantive aspects of his pleading, It's basically a motion or request for order. And that was filed, I think, 8 days ago, 7 or 8 days ago. And if Your Honor were inclined to consider it, I would respectfully request another week to be able to respond thereto. I don't know that it's necessary, but I would say that his filing of the response is procedurally inappropriate, and there is no NRS or EDCR or NRCP that would allow them to respond. And frankly, this came up on disqualification motions. If I were to allege bias vis-a-vis the bench, it's really between, I want to say between me and the judge. And whether they perceive or don't perceive bias is of no moment. And so I would ask, I had contemplated briefly filing a motion to strike under Rule 12F to strike their response, but not wanting to make waves and wanting to be deferential, I refrained, and I thought it would be sufficient to object here today. And I would ask that Your Honor not consider it, but if Your Honor does, please give me another week to respond to it. And that's all I would say.
Thank you, Mr. Phillips.
Thank you, Your Honor.
Mr. Waite, do you have any questions for Mr. Phillips?
Your Honor, I have argument when you're prepared to receive it, but I would perhaps ask questions if you felt that it was necessary to go through some of the things that were in my response, for example, to have him respond to emails that were set forth there that he sent additionally to Ms. Wilson, to me, to the counsel that I obtained a declaration from in Michigan, and some of those other types of things, if you felt that that would be helpful for your guidance. I think they've all been properly attached and authenticated and those types of things from an evidentiary standpoint. But if you'd like for me to ask some questions of him, I'm happy to do so.
No, I'm just asking in case.
No.
I'd like to have a full and
Sure.
fair. The order to show cause is the case initiating. For today's purposes, you filed a response. Mr. Phillips has filed an affidavit. They're both on file in the court. I think they stand alone. They've both been considered and given equal weight. Okay. I anticipate, Mr. Waite, you don't wish to ask your own client any questions?
That's correct, Your Honor.
Perfect, okay. I've heard from Mr. Phillips as to his position on this case. Is there anything that you wish to state, Mr. Waite?
By way of argument?
By way of argument.
Thank you, Your Honor. This is really in response to what I've just heard, so to the extent it's a little disjointed, I don't really have prepared remarks. But I would say, Your Honor, that the exchange between you and particularly Mr. Phillips's responses make it painfully obvious that he either does not recognize, he's either incapable of recognizing or refuses to acknowledge what a meritorious claim is and these types of things. He said repeatedly that none of his actions were frivolous, all of them were well-founded, they were meritorious. He earnestly believes everything he filed was proper. He sincerely believed the same. Your Honor, with all due respects to Mr. Phillips, who's a nice enough fellow, I mean, he doesn't have two horns or anything like that, but he thinks what no one else thinks. And with all due respect to his representations, they're in my response, there have been courts that have found that motions and various things were frivolous and lacking in merit. So he lacks the ability to supervise himself and to be a gauge and a self-censure of himself. Even standing here today, he believes that everything he did was good, true, accurate, righteous, and that's just not the case, repeatedly over and over again. All of the emails that you went through with Ms. Wilson, that he sent to Ms. Wilson, well, Your Honor, you have to take those in context. Well, that's just not believable. First of all, looking at the substance of those emails, and if you have to look at them in context, why is it over and over and over again? And not just with Ms. Wilson, with me. In the other case where I defended Ms. Wilson. In this case, where I'm now representing Ms. the attorney that he sued in, not the attorney that he sued, but the individual that he sued in Michigan, his communications with that attorney. Going so far as to filing a bar complaint against that attorney because she hinted that she might file one against him in California. And so in a preemptive move, he filed it. This Michigan State Bar determined there was absolutely no basis for it. He appealed that decision, and the Court of Appeals in a one sentence said, this doesn't even merit oral argument, and affirmed the order of dismissal. Also, Your Honor, Mr. Phillips time and time again said, well, Ms. Wilson didn't file a Rule 11 motion, Mr. Waite didn't file a Rule 11 motion. He's wrong when he says no court has found anything that I've done frivolous and so forth. Is that the gauge? Again, that's more of an indictment that he has to have a red light. Otherwise, it's a green light. It's always a green light to do whatever he wants to do for as long as he wants to do, as deeply offensive as he can muster, until someone says, no, you've gone too far. We're hoping that Your Honor will give him that red light today and send him that message that, Mr. Phillips, you are wrong. You have crossed boundaries, not once, not twice, repeatedly. And enough is enough. Furthermore, I don't know that pro bono attorneys have better things to do than to file Rule 11 motions. I mean, I did file a motion to have Mr. Phillips referred to the State Bar of California. I served 12 years on the State Bar of Nevada Disciplinary Committee. I know that a referral to the State Bar coming from a judge carries much more weight than a referral coming from opposing counsel. I tried to get Judge Henderson to make that referral. I think he came very close, but as he said, he's never referred anyone to the State Bar, and he was hesitant to do so now. I think that's what Mr. Phillips was referring to when he said Judge Henderson declined to deem him a vexatious litigant. That wasn't the issue. The issue was whether to refer him to the California State Bar. His references to, I don't know why it matters whether a threat is a litigation threat or some other kind of threat, but while a litigation threat may have some ameliorating factor in some other context, it is very relevant for purposes of a vexatious litigant motion. If he's threatening litigation, and he wants to call it a litigation threat, well, okay. But that's what we're here about, and that's what he's done over and over and over again. Your Honor made the point for me where he's mentioned a couple of times that he wants to close this case. He's tried to do that, and we've refused to do so. If he wants to pay the outstanding fee awards, we'll close the case. There's nothing else to determine. But he hasn't paid. He hasn't even made an effort to pay any of those fees. So that may be coming down the pipe, but he controls that by paying the fees. Is he a vexatious litigant? In your order to show cause, Your Honor, at page 5, you quoted Judge Henderson where he indicated that Mr. Phillips was, and I want to make sure I get the words exactly because you quoted them, quote, among the most obsessed and uncontrollable of vexatious litigants, end quote. And I believe that Judge Henderson, who was sought to be disqualified 3 times by Mr. Phillips, was denied by the Chief Judge all 3 times, but finally, as is, I think, Mr. Phillips' intent, he just wears the judges down until they wave the white flag of surrender, and even though Judge Henderson had prevailed 3 times, he disqualified himself. But you know what happened after that? That was interesting. He recused himself, but Mr. Phillips didn't want that. He wanted the judge, the Chief Judge, to enter some findings of wrongdoing or whatever, and he wanted it to go back. Well, the Chief Judge did send it back because when Judge Henderson recused himself, he didn't give a reason. So then we got a reason. I think Mr. Phillips may regret that because Judge Henderson issued a very scathing order, not favorable to Mr. Phillips at all. Your Honor, I just have to shake my head when he attributes these slash and burn litigation comments to Shannon Wilson. That's just reprehensible. I mean, I know Shannon Wilson. That's all I'm going to say about that. I will point out, since in response to in his affidavit, he makes reference to my response, and this EDCR 5.509 is what he's referring to, and somehow that's a motion or whatever. That has no application here at all. So if you've looked at that, that has to do only with orders to show cause for contempt, not orders to show cause, as we're here today, to hold one as a vexatious litigant. Has there been notice and opportunity to be heard? Absolutely, he's here. He's defended himself and answered questions. Is there an adequate review of the record? That will be up to you in your order, but I suggest that based on what's in your order to show cause and what's in the Exhibit 2 to my response, the compilation of the cases, you can make a very adequate record. More so than in instances that have been sustained by the Nevada Supreme Court on reviews of vexatious litigant orders. Substantive findings of frivolousness or harassing conduct. Your Honor, and I set this forth in my response, numerous times Mr. Phillips would file appeals, for example, and not pay the filing fee. They get dismissed. Courts have found that filing actions and not paying the fees is indicia and evidence of frivolousness. Filing actions, not serving them, is also indicia of frivolousness. Filing actions, serving them, but not proceeding, and then stipulating to dismiss them. All of these actions, when you look at them, with I think the exception of the one that I list that is still ongoing, where he sued another attorney, which is I can't remember which one it is, Your Honor. I'd have to look at it, but with that exception, all
On page 8
on page 8.
of your Exhibit 2. Says this action appears to be ongoing.
Yes, the Jennifer Abrams case, another attorney in town. With the exception of that one, when you take a look at these, none of these actions have really gone very far. They've all been dismissed at an early stage. I do agree with Mr. Phillips to the extent that Nevada case law, Supreme Court has said that it's not so much the numerosity of actions that someone files, it's really the quality of those actions that have to be looked at. But there are so many actions that he's filed, and when you look at the quality of those actions, not paying fees, dismissals very early, comments, the judge in Michigan on the way out dismissing the case said, this looks to be like a frivolous case, and so forth. All of those add up. Also, the Supreme Court has talked about the harassing, intimidating communications to opposing counsel and the court. I won't go through those all again, but they are numerous. They are numerous, they are disrespectful to counsel, to the court, and they just can't be tolerated. Mr. Phillips can come here and say that he's sincere, that they're taken out of context, but you would have to suspend your common sense and reading abilities to conclude that they are anything other than mean-spirited, harassing, intimidating, and that's just his means of operation. Narrowly tailored order, Your Honor. As much as I would like the court to issue an order that would preclude Mr. Phillips from filing actions anywhere and everywhere, the court doesn't have jurisdiction to do that. I think Mr. Phillips fails to make a distinction. Somehow I think he thinks that this court and the 8th Judicial District Court are different courts. Of course, they are not. And so you can certainly, and I believe it's under the authority of, I think it was the Jones case, maybe it was Jordan, it's cited in the brief. you can tailor your order, and it would be narrowly tailored to have pre-filing restrictions in the 8th Judicial District. I think he would want you to limit it to just this case. Mr. Phillips kind of takes the view, well, Your Honor, this case is over, and there's nothing else to be done here. I don't intend to file anything more in this case. Well, again, that's factually not correct, because there may be some collection efforts that undertake. He may file some things, but more importantly, this order to show cause, Your Honor, is while a vexatious litigant order must be narrow, it's not so narrow as to preclude filings in a case, but instead to preclude filings in a court. And this court is the 8th Judicial District Court. Even at that, the order that I propose isn't an all-inclusive before bar to everything. He still has the right to take something to the Chief Judge or to Your Honor, if Your Honor wants that responsibility, but to have some judicial officer take a look at his proposed pleading to see if it has merit. If it hasn't already been decided somewhere, he's prone to doing that, or if it implicates some fundamental right. I agree with him there as well. The Supreme Court has indicated that. But he's demonstrated himself that he is not a good judge of those types of factors. And that has to be delegated to someone else. If he wants to file 14 other lawsuits, I suppose that's his prerogative. But he needs to have a gatekeeper, someone who can look at those and say, Mr. Phillips, these 13 lack merit altogether. No, the answer is no. This one you can file, or whatever the case may be. Because again, he is incapable or unwilling to be civil and to, I'll just end with this, Your Honor. Mr. Phillips has forfeited his right to file actions in this court without prior judicial approval. And we would ask that some form of stern, vexatious litigant order be entered so that this court, and by this court I mean Your Honor, and all the other judges within the 8th Judicial District, can go about their business of resolving meritorious disputes for those people who have been waiting long enough, too long, instead of consuming resources by, I hesitate to say, but I've said it to Mr. Phillips numerous times, with his nonsense. And that's what it is. So unless Your Honor had anything else. Thank you, Your Honor.
Sir, you get the final word?
Thank you very much, Your Honor. I'll try to be brief here. When I said that no actions were found to be frivolous, what I meant by that is in all the multiple proceedings in federal district court, not one of them ended with this case is dismissed on the basis of frivolity. That just never happened. There's always been a well-reasoned decision, and by and large they've all ended under the immunity doctrine, judicial immunity, and or 11th Amendment immunity. I think a lot has been said today about vexatious intent. It's my specific position that there's no such thing as vexatious intent. Either a person violates Rule 11 or they don't. Judge Henderson did consider briefly declaring me vexatious, and he even publicly ordered Aaron Ford's office to pursue the matter. I thought that was inappropriate because, after all, Aaron Ford was Judge Henderson's attorney, and to some extent, he has, well, it could be said that he's waiving a privilege when he publicly asked Aaron Ford to do something. He could have just called him up and say, hey, proceed against Phillips, but nobody, the Aaron Ford's office has never filed the Rule 11 motion and alleged that what I'm doing is frivolous. The reason that Judge Henderson gave for not declaring me vexatious, because he said that Mr. Phillips will certainly file a flurry of motions, was his exact language. And I told him in open court that I would, because again, I believe it's I know it's a First Amendment right. It's the right to petition the government for redress of grievances, and the vexatious litigator remedy is reserved for only the most extreme cases. And even though I have a poor win-loss record, if you will, there's just not the kind of rambling and vagueness that you see in pro se pleadings. The business about threat, I thought the way Shannon Wilson was comporting herself was inconsistent with the rules of professional conduct. Mr. Phillips is threatening this one, Mr. Phillips is threatening that one. She said I threatened the school, which was clearly in reference to me threatening to ostensibly bomb my son's school and shoot up my son's school. And then Jennifer Abrams, her paralegals, had gone online. Phillips is crazy. He's threatening to shoot up his son's school. He's threatening to bomb the school. And so I sued Jennifer Abrams and her paralegals for defamation. And that's a well-founded cause of action. The case right now has not concluded because the senior judge program has not been able to find a judge. They filed an anti-SLAPP back in 2021, and pursuant to NRS, there is 21 days within which for the court to resolve it. Well, it's been 4 years now, and the case is just on ice. I think this is a grave miscarriage of justice, because if I could go forward, I can easily prevail on defamation per se, because the defendants admit making these statements that attribute and impute criminality to me. Well, there's no evidence I've ever bombed a school or phoned in bomb threats. It's just utterly ridiculous. And I was enormously critical of Shannon Wilson when she said to the court that Phillips threatened the school, because it's simply not true. And later, Mr. Waite tried to equivocate and say, well, what Shannon Wilson meant is that Phillips threatened to sue the school. You know, that's completely different, because it's legal to tell the school, I'm going to sue you. There's a First Amendment right to convey that message and a First Amendment right to sue people. But the way she would say threat all the time, Shannon Wilson was hoping that the listener would hear threat, 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 and to vindicate their allegations of domestic violence. With regard to Mr. Waite indicated that I had lost some of the actions in all of the actions in federal court, and I would file a notice of appeal but not pay the appellate cost. Well, that's not done for any frivolous or harassing purpose, because merely filing a notice of appeal requires them to do nothing. What would happen, the reason I didn't pay the fees is purely down to economics. I just couldn't afford the $605 fee for the Ninth Circuit. So that's why that would happen. The slash and burn quote is an exact quote, despite what Mr. Waite said earlier. That is exact language from Shannon Wilson. She called it slash and burn litigation. Again, the DeLong case, DeLong versus Hennessy and Jordan versus DMV, they cite no statutory basis for Mr. Waite's response. Now, he talked about filing some of these cases, civil cases, and then them being dismissed. Well, I think the inference to be drawn is that there may be a settlement, you know, without me running afoul of some, confidential settlement agreement. I remember reviewing the 8th District rules as well as Nevada rules of civil procedure, and there's no strict requirement to give a notice of settlement. And so if I file a case and it's soon disposed thereafter, without me coming out and saying it, there may be the inference to be drawn that the case simply settled. But I have filed many actions in civil court here in Nevada, but not one of them has had any kind of problems. Now, I know here in family court that the judges have been critical of me and that they've been upset with some of the filings, but in civil court, I have never had any kind of problems with any filings. And there have been a couple motions where the defendants would file a 12B5 motion, and they're argued, but I've never had, again, any problem in civil court here. And I can say also, I mentioned it briefly in the affidavit, I have a class action lawsuit right now in the Ninth Circuit or I'm making arguments based on Troxel versus Granville and some of the other, Prince versus Massachusetts, Wisconsin versus Yoder. And we are invited to oral arguments on February 10th, and I'm excited to be there. And I would point out that I'm making the same arguments in this class action lawsuit in the 9th District that I'm making here. Sure, I lost the cases, but, well, finally, Mr. Waite talked about consuming resources. It's his opinion that I'm consuming too many resources. My opinion is that I frankly should be able to consume as many resources as I believe are necessary to fight to try to see my son or otherwise establish some sort of precedent. But that being said, I'm reasonable about this, and I think Mr. Waite is not unreasonable. If truly the aim is to stop consuming resources, I would urge the court, to the extent I'm able, to say if we could close this case, I don't anticipate any more filings. But if there were a vexatious order, I would want to appeal it or file a declaratory relief or some writ of mandate to Carson City. But I'm hoping Your Honor won't do that, because my attention, is elsewhere. And again, the minor child issue has already been disposed. And again, for whatever equitable considerations this adds to the case, I had no contact of any kind whatsoever from the time my son was 12, and then when he aged out at 18, no contact of any kind whatsoever. And frankly, I don't think I've ever met anybody who's had it as rough as I have. And so I think that the court would have to expect that I'm going to fight to recover constitutional rights wrongfully taken. I think I've done it, professionally, and I do believe that everything I filed was meritorious, even though it lost. And again, it's not like the federal actions. They said this is completely crazy legal theory. It just got stopped by judicial immunity and or by 11th Amendment immunity. But in terms of the pleadings, I believe they all have merit, and every motion I filed in this case, I do believe have merit. And if we went over those, I don't know how much time we have, but I think I could show the court that they are intended. And if I had written something that was truly horrible, it wouldn't even require a response. But I get a full 15-page brief almost every time from Shannon Wilson or from Mr. Waite. And if it were truly that poor what I was writing, they could simply say this is vague, ambiguous, unintelligible, and not based on fact or on law. But they've never done that. They've actually had very detailed, very explicit responses, because my arguments, I believe, are meritorious. And it's a shame I didn't prevail, but again, my only hope was ever to see my son, number one, and number two, to create precedent if it were possible. And with that, Your Honor, I would respectfully rest.
Thank you.
Thank you, Your Honor.
All right, I'm going to give you a oral decision from the bench.
Okay.
Doesn't have any punch to it until it's reduced to writing. Once it's reduced to writing, you'll receive the written order, followed by a notice of entry of order. Upon notice of entry of order, sir, you'll have to decide what course of action you want to take, whether or not it's appealable in its own right, or whether or not a writ is appropriate. Understand? Sir, do you understand?
Yes, I do.
Okay, perfect. As I noted at the outset, this was an order to show cause issued by the court, filed on January 2nd, 2025, duly served, as amended on January 23rd, 2025, duly served. The amendment added the city and state and the actual courtroom designation within the courthouse, as opposed to just our department letter. Court finds pursuant to Jordan v. State, which is 121 Nevada 44, a 2005 case, cited on page 1 of the order to show cause, that Mr. Phillips was provided with reasonable notice. He was given an opportunity to oppose this proceeding and offer testimony today.
Thank you.
You're welcome. The purpose of the order to show cause was to set forth a list of cases and documents as explanatory for a vexatious litigant designation. My mandate is to issue an order that is only so narrow as to what is necessary to curb repetitive or abusive actions. And sir, I want to stress to you, this isn't about your win-loss ratio. It's about the amount of filings that are frivolous, that are clearly for the purpose of harassing or being vexatious. We provided a list related to this case. I note for the record that the child that you share emancipated in 2023, and more than half of the pleadings that we listed relative to this case occurred after his emancipation. I'd note for the record, sir, that counsel for plaintiff provided an 18-page list of cases unrelated to the domestic case, other forms of litigation, other types of litigation, and other forms besides just this one. I've been an attorney for almost coming up on 25 years. Of all the cases, I mean, with all due respect, sir, I've never seen a clear case of filing pleadings for the purposes of being vexatious and to harass. The pleadings that were included in this case include documentation and correspondence that suggests an absolute settled purpose to engage in litigation for the purpose of harassing. We included just a snapshot in the order to show cause. It was certainly not meant to be a totality. It was just the most recent that we found once this case was assigned to my department. I will be issuing an order, sir, deeming you a vexatious litigant. You're going to receive, as I noted, a written copy of that. It's going to have those substantive findings that are required under Jordan. You will be required to submit directly to my department related to this case anything prior to filing it with the clerk's office. If you file something without submitting it to me, it will be deemed stricken. You'll receive minutes indicating there's a vexatious litigant order, you didn't comply with the restrictions in the written order, and if you comply with it and there's a meritorious basis to file in this case, then it'll be allowed to be filed. This is the 8th Judicial District Court. We are a part of that court. That includes filings in other divisions in this court. So if you choose to file an A case, for example, that'll have to go to the chief judge. If he designates that comes down to me, that's his prerogative under the local rules and the statute. He has certain latitudes in that regard. Only he can assign. Okay. So if that's his decision, I'll abide by it, or anybody that's assigned to this case. Pursuant to my written order, sir, the vexatious litigant order will go to the Nevada Administrative Office of Courts, and you will be entered into that database. The order from this court will also be sent to the California State Bar, noting that you've been deemed a vexatious litigant in the state of Nevada, County of Clark. Okay? Mm-hmm. Okay.
One thing for the record, Your Honor?
Yes, sir.
Your Honor mentioned that since the majority of these filings for custody came out after the minor child aged out in 2023, the point of correction is that he had aged out, make sure I got the right year here.
I believe he was born in 2005, sir. Is that correct?
Yes, it is. Yes, that would be correct. Yes. Yes.
All right. So again, sir, today is just a hearing, and I'm giving an oral decision from the bench as a courtesy to everybody present, so you don't have to wait for a written order to come out. But understand that there's a case called Rust that states until it's reduced to writing, today is just a hearing. I'm letting you know my oral decision, my written decision will comport. If you choose to file an appeal of any kind, you must wait for that written order to enter and notice of entry of judgment. I don't want you to cause any procedural issues. Obviously, if you choose to file an appeal, you do that directly to the Nevada Supreme Court because it's an appeal of this order. You file it direct. Makes sense?
Yeah, may I ask a question here? Because I don't know what exactly Your Honor is contemplating, but if I wanted to file a civil matter, or if I had a civil case that were ongoing and I wanted to file something...
In Clark County? In
Clark County, yes. Would I have to get permission from Your Honor or from Jerry Weiss?
So for cases that are for documents related to this case, your D case, those will come to me for review or the judge that's assigned to this case. Okay. For other cases in the 8th Judicial District Court, I'm a specialty division. The family court is a specialty division of the 8th JD. Those presumably would fall under regular civil criminal. So my order will be that those have to go to the chief judge. But pursuant to his authority under EDCR 1, if he's like, that's gonna go to the judge who's most familiar with these. We can do everything that civil can do, but they can't do what we do, okay? So there's a possibility that the chief judge in his discretion might say, it's gonna go to Department X. They'll make a decision because we have that ability to look at civil cases. But it's gonna be his discretion, sir.
Okay.
So if it's anything other than this case, it would go to the chief judge's office, and that rotates every couple of years, so you wanna keep track of that,
Okay.
okay? And then if the chief judge makes a decision, he or she might say it's gonna go down to Department X.
And another question, if I may, Your Honor.
Sure.
If they were to file a motion, and within 14 days, if I wanted to respond, do I need leave of court to respond, or may I respond as a matter of course?
You need, anything that you're gonna file from here on out, sir, needs to come to the court for review. And I do wanna stress that my decision in this case does not impact any previously entered judgments. For example, financial judgments are not impacted by today's proceeding.
Okay. And if I were to file something, say in civil court, or wanted to file something in civil court, and I were to run it by Chief Judge Weiss, and if Chief Judge Weiss were to reject that filing, what remedy, if any, do I have?
That's right, I don't know, I can't give you legal advice.
I mean, is there?
It would depend on what the chief judge said. You'd have to look at what he or she indicated.
Okay.
So
well,
I
thank you
I
very
have
much.
no idea what they might say, but you
Thank
would
you
have to
very
rely
much,
on
Your
it.
Honor.
All right, you guys take care,
I
thank you,
have
Deborah.
one clarification, Your Honor. I
Yes,
just want to make sure that you were not giving Mr. Phillips any legal advice when you referenced an appeal.
No, I give
that he-
everybody the same appeal admonishment.
He has to make the determination of
Yes.
the correct procedure, whether it's an appeal or a writ petition.
My habit in every single case when I issue an order is to provide an appeal information, because 65% of my litigants are pro se, and it's a habit from
Yeah.
being in criminal. I always let everybody know.
I just don't want him running to the Supreme Court on an appeal saying, well, the judge told me that my course of remedy.
You can see it in every single one of my cases.
I did not consider anything, Your Honor, to say to be legal advice, but rather spoken in the ordinary course of the proceeding, so.
All right, good luck to you, sir.
Thank
Thank
you
you,
very
sir.
much, Your Honor.
Thank you. We're in recess, folks.
Off record, Your Honor.
Thank you, Ms. Green.